Welcome to the Measure Success podcast and also a part of our $4 million Strategies podcast. Really excited to have us with us here, Jenny Sheridan. She has her own firm, JL Sheridan Law, Silicon Valley boutique firm specializing in technology, transactions, IP, data privacy, compliance. She has wonderful experience and she has a JD from Columbia Law School and a master's degree from Tufts University as well, and several other things. She's also been an adjunct professor. I have worked together in the past. She's one of my favorite people. And Jenny, welcome to the show.
Thank you, Carl. It's a pleasure to be here.
Okay, you're going to be tackling a topic that probably people don't want to hear, right? This is the challenge of, we have the California Consumer Privacy Act. It's in effect, but there's new regulations that are coming on board. First of all, from a high level perspective, share with our audience what that is.
Yeah. So, these days now, probably many people have heard about privacy laws around the country because this is, again, a very current development. But we did lead California in 2018. We passed California Consumer Privacy Act, CCPA. It was passed by the legislature. What happened, though, in 2019 is we had a proposition that amended that and added a lot of new regulations, but also created an agency. We're the only one of its kind in the country. We have an independent standalone agency to enforce the law and to draft regulations. So there's been a lot of activity to basically stand that up. But in the meantime, there has been enforcement both by the Attorney General and then now for the agency on these obligations. Now, at a high level, what I would say that not just California, but now as of 2025, 16 states have consumer privacy laws. And the one key difference for everybody is all of them except California apply only to B2C businesses. You're focused on the business to consumer, not business to business. California is different. We're like the EU and UK, if you're familiar with GDPR. We cover B2B and employees. But let me talk again at the high level, the overlap. Really what the concern that I would say that really was a catalyst for these laws was the ad tech industry and tracking the individual consumer. So that was really, again, I would say the initial momentum was about let's give consumers choice and the ability to opt out of that targeting. I advise businesses, the regulators are taking that very seriously. So if you're a B2C company and you're doing targeted advertising, you better have the right disclosures on your privacy policy. You better have a working, and I can't emphasize that more, a working opt-out mechanism. I work now with clients where we do forensic audits, so we know what's on the website, right? Many businesses don't. So that's really the basics that you have to have. Now, where that's changed is the sensitive information. That's what has been getting the attention of state regulators. Think about it like whether it's precise geolocation and issues around tracking people going to reproductive health centers, whether it's children's data, whether it's health data. I have a lot of clients now in that space. I didn't even realize this 10 years ago, the narrow scope of HIPAA. We probably all know about HIPAA, right? But it only applies to covered entities, typically your doctors and hospitals. So if you're in the consumer health space, HIPAA doesn't apply. So now we have a standalone law in Washington that is very aggressive. And I'm not going to dive into the details right now, but if you're doing things in consumer health, biometric, neural data, all of these things now have even higher levels of obligations. In most states, you need opt-in. There may be some restrictions on selling or sharing that data. So I'll stop there and take more questions, but if that gives you a flavor of, what the landscape looks like now.
Okay, let me hit on the brass tacks here, so to speak. What type of penalties do companies get as a result of not following these rules in the state of California or related industries?
So my answer to this always when clients ask this, and there are penalties and they may not seem that severe when you look at, they'll say for an individual infraction, usually in the, low thousands of dollars, but that's not where the pain happens. The pain happens if you have an inquiry, especially if you're a privately held company, like most of my clients are, just to respond to the Attorney General or to the agency, if it's here in California, is going to take an inordinate amount of time that your business people probably don't really have time for, right? I mean, when I work with them, it's challenging enough for them to take the time to give me the information that I need. And I joke with them, I'm like the friendly regulator. I'm giving you an idea of what a regulator would be asking. So is that opportunity cost to just be able to have to respond to it? The reputation cost. I mean, the first attorney general action against Sephora was, again, very painful for them, just as customer relationships, right? Like, we're not a privacy, they've worked hard at it now. Not going to, I'm not saying, trying to point them out for that reason, but it's just not a pleasant experience to go through, to, again, have been labeled by the attorney general that you have a problem with privacy. So the individual fines, and they vary across the different states, but they may not look that high. And you would think, oh, that's a cost we could afford. But I'll tell you another thing too. I mean, when these consent decrees come out, I think the last one with Todd Snyder, and again, I didn't prepare this, so I might be misquoting, but I think it was around 600,000. They've been over 1 million. The Texas Attorney General just announced one over 1 billion. So they can add up, because the way that they count these infractions is they can add up. But that's not the biggest cost to the business. It's going to be the opportunity cost of having to respond, and it's going to be, again, the reputational.
Wow. Yeah, well, once again, you start getting those higher numbers because you're saying per event, right? You add up if you have a lot of different parts. So let's just, once again, from an example standpoint, let's say somebody does an email campaign, right? And they do 1,000 different emails, and they don't have an opt-out type feature in it, right? But it's clearly a blast, right, that they did if you go into it. So in that case, would that be an example of they theoretically would have 1,000 potentially transactions that they've done on that?
But honestly, we're more in Can Spam Act there. Just to bring it back to CCPA, I talk about, again, with these opt-outs.
Thank you. The opt-out. Yes. Thank you.
And here's what has happened with, like, Honda and Todd Snyder, the ones that have been public, is they've come from customer complaints. And so it's typically things like the customers are trying to exercise their rights. So that's another big part of all of these laws. They want you to have access rights. So you as a consumer should be able to easily make a request for access to your information, delete your information, correct your information. So they start counting all the instances where you fail to do that, and they check your opt-outs, because, again, I remind clients, a regulator, anyone can do that. They can go to your site and check and see if it's working. So they just add those up. So yeah, that's why the count can get high.
Wow. Very painful. So once again, somebody's listening to this and they're business owner, right? You're right. People are managing risk, regularly. And I appreciate how you said that. It's like one thing could be the fines, but the other thing is, once again, the energy and effort for an average, an average small business like you're referring to that you're working with, to help put these policies in place properly, right? So they will pass the bar, so to speak, with the law. What is generally, there's two costs. One is working with somebody like you to get the actual legal part, but then there's actually implementing it from a website perspective.
Yeah.
And once again, I'm not putting a spot, I'm not saying your things, but if you'd like to do a broad cost, right, to help set this up and do this the right way, what is that? What does that cost generally for a company to do things the right way?
And again, it's more than people think, because there's OneTrust and Transcend and TrustArc. Again, I'm not voting for one or the other. I'm just saying they're all out there, privacy tech vendors that are really trying to help companies be compliant. But they're not plug and play. It's like you first have to do manual work. So the first thing that I always talk about with clients is data mapping. Do you know where your data is? And I think that this can be turned to an advantage, and more companies are doing this. Data is an asset. So it's just about using it responsibly. And so if you do that, again, it's going to be a positive business growth for you, but you need to work with somebody that can help guide you. So you first have to understand what's the definition of personal information or personal data, because those are used interchangeably, right? So one of the things that I found was a challenge a few years ago was U.S. companies not understanding that indirect identifiers like device IDs, IP addresses, those are treated as personal information or personal data. So you need, at just a basic level, like for CCPA, You need to know within your own internal systems, where is that personal information going? And then outside your system, what are the third parties? We call them either service providers or third parties. And I'll explain briefly what that means. A service provider is an entity. It could be like Amazon Web Services, a support vendor, something like that, who is processing that personal information just for your business. They're not using it for other purposes. CCPA gives them the covered business kind of an out as far as having to worry about this do not sell or share my personal information that we have to that opt out, because the service provider is basically an extension of the business. But if you're working with third parties, particularly ad tech, that are doing other things with that information, again, it's, you think about with the metas and those, it's going back into their system to help improve their system. You have to have a different agreement with them to be compliant with CCPA. You can't do any of this if you don't know in the first place what your data flows are. So one of the things that I do, I call it level 1 and level 2. It's helped because most of my clients don't have in-house counsel, maybe 60-40, something like that. So what I've done is I've said, okay, here's level 1, and it's on a flat fee, but here's what we're going to do. We're going to go in and I have a questionnaire. I'm going to have an interview with you. I'm going to understand the data flows. And then I can draft a compliant notice. And that's layered because we have to have a notice for California that's very specific and very prescriptive. We possibly on the cookies, depending on what you're doing, will have a separate disclosure about that. If you're doing consumer health data, we need a separate notice for that. So we'll do those website, again, the things that the regulators would be seeing. We'll do that in level 1 and also do a high level roadmap analysis for you of what are all of your compliance gaps, challenges, like again, around vendor management. That's a key part. What are your security controls? Do you have an information security officer? I mean, my B2B, Carl, my B2B clients, they get that, right? In the SaaS world in Silicon Valley. What I always say about my B2B clients is it's their customers that are driving compliance. Like you can't be a serious contender in the SaaS world, and it's typically global, if you don't have a CISO, if you don't know what SOC 2 is and probably have at least for your product environment, if not your whole environment. These things are just standard now in the B2B. It's not in the B2C. And so I work with clients to explain to them why they need for this, for incident response. What are the challenges that come in the security side? Now, the operational challenges that we go through are, yes, you get an opt-out. Okay, to answer your question too, what else are they going to need? It's for a B2C company, I think it's very challenging for them to try to do that themselves. They're probably going to have to work with some vendor. There's less expensive and more expensive. But the key in doing that effective opt-out is categorizing your cookies and your tracking technologies. So I work with marketing. I mean, they're smart people. They get it when I talk to them about, hey, you've got to make sure that those cookies or tracking technologies that are tracking personal information to, again, third parties in the ad tech system, they are categorized correctly so that if I, as a consumer, go and opt out, I'm opt out of that because that's what regulators are checking. So again, you can do it on a lower budget, but you've got to have the attention to it to make sure that you're doing it correctly. So that's my level 1. I'd say my level 1 reduces a lot of risk because again, we've got the notice up. And here's another thing. I mean, I just did not trying to scare people, but to say this is what I've been predicting is coming. Talk about AI. Regulators are going to use AI. It's just, why not, right? And so I've already seen a notice in a European country. I'm trying to remember which one, but in Europe for GDPR, they have data protection authorities for each country. And one of these countries announced that they are basically, again, using AI to scan websites to see who might be out of compliance. So that's why I say that level 1 is really key because that, again, mitigates your risk significantly. It's more likely you're going to get, again, if you have a customer complaint, maybe you'll come to the attention of regulator and then they'll look under the hood. But then level 2, for either my clients who have higher risk because they're processing sensitive information, like those things I was talking about, geolocation, children's data, consumer health data, they need to think more about, again, the inner workings. Again, do they have a written information security policy? Do they have training within the company on it? Do they have role-based access and training? Do they have, again, all of the assessments that they need to do for sensitive information. That's what I work with clients on the level 2.
Perfect. Okay, that's great. Okay, we just have a couple more minutes here. If organizations, once again, they just have like one thing, one thing they should follow up, like to take an action, what should they do next?
Well, what might help me is just give me the context. Because one of the things that I look at for when I do an initial complimentary call with clients, and I'm looking, are you a B2B? Are you a B2C? Are you just in the US? Are you global? Are you processing high risk? Okay, because that's the spectrum. If you're a B2B company not doing target advertising, with an asterisk, Carl, more and more of my B2B are using LinkedIn with lookalike audiences. They're in for target advertising, but let's assume you're not. Like I said, privacy is going to be driven by your customers and what they require of you. But here on the other end, you're a B2C, you're doing target advertising, let alone even some other sensitive information. You better have a conversation with a privacy professional just to address what your potential risk could be and what you could do to mitigate your risk.
Jenny, how can people learn more about what you're doing and connect with you directly?
I'm right on LinkedIn, so I don't know if that's going to be shared, but please go into LinkedIn, and happy to accept any invites and chat with people.
Yeah, so once again, for those who are listening, go to Jenny Sheridan, just like a JennySheridan. Jenny Sheridan. You can go on LinkedIn and help connect with her, and she'd be happy to help. Ask some questions to go some additional part. And Jenny, had something else to say here?
It might be Jennifer Lynn Sheridan on LinkedIn.
Thank you. Thank you. Thanks for clarifying that. That's perfect. Yeah, of course. Jenny, hey, thank you so much for being a part of our podcast today.
Thank you. My pleasure.
And to whoever else is listening, hey, these are the type of things that can really derail your business. We sometimes, I understand as business owners, we sometimes make these risk decisions. But if you have any questions about this, especially if you are doing business with the state of California, I encourage you to reach out to Jenny, get some initial insights to see if you should be making some changes. As we always like to say, wishing you the very best and measuring your success. Have a great day.